that, and just aware that this bill has just been foisted on us recently, so I'm wanting to make some relatively general comments, but largely around process. And the first thing I want to know from the Minister is, where is the Attorney-General's report? Because the Departmental Disclosure Statement, under the heading Consistency with the New Zealand Bill of Rights Act, indicates that there has been an assessment of the bill and whether it's consistent with the New Zealand Bill of Rights Act. So that advice has been provided to the Attorney-General. Now, if you're going to introduce a bill with an hour's notice, then we should be seeing on the table the advice on the New Zealand Bill of Rights Act. And it is shameful that the advice exists and yet it has not been tabled, because I want to know what the expert advice of the Attorney-General and the Minister of Justice is on this, particularly because there are changes to offences in this piece of legislation and there are retrospective provisions. Now, you are a member of a party which prides itself, or purports to pride itself, on its adherence to the rule of law. And frankly, to come to this House in this kind of haphazard way is absolutely contrary to the rule of law, particularly when you're introducing retrospective provisions. I am appalled to see when your leader is pushing a regulatory standards framework which talks about consultation, that there has been no treaty analysis done whatsoever. It says here in the disclosure statement, due to ministerial time constraints, Honourable Brooke van Veldon was busy, no analysis on whether the bill is consistent with the principles of the Treaty of Waitangi has been done. Why not? Because we know our lowest paid workers, many of our lowest paid workers are Māori. And in terms of doing right by Māori and ensuring that they are paid appropriately, wahine Māori are directly affected by this bill, and a treaty analysis was absolutely necessary. And I also note, towards the end of the disclosure statement, that this bill is retrospective. That is to say that under urgency, and to be perfectly honest, on this side of the House we don't understand why it's so desperately urgent, you are introducing a retrospective aspect, in particular.
The Chair is not introducing it.
Pardon?
The Chair is not introducing it.
Sorry, Madam Chair. The Minister is introducing a bill with a retrospective aspect, in particular that there are clauses in contractual agreements which are being struck down, namely review clauses. These are clauses which parties in many cases have reached by agreement. They have negotiated these review agreements. Sanctity of contract is something that the Yak Party talks about all of the time, and yet here they are legislating away contracts that have been struck between the parties. The process here is appalling, and I want to know why the Minister thinks it's appropriate to retrospectively change contractual agreements. And I guess the other thing in terms of that disclosure statement is, why was the Ministry of Justice not consulted around the criminal provisions? This is not a difficult thing to do. It is not difficult when developing policy. I see other ministries, Public Service Commission was consulted, Health New Zealand was consulted, the Ministry of Education was consulted, Treasury was consulted. But when you are changing criminal offences, it is absolutely appropriate and necessary to take the advice of the specialist ministry, which is the Ministry of Justice. Clause 3.4.1 says, no, we didn't consult the Ministry of Justice about those offences. And then there's this. In terms of regulatory quality, the standard of our legislation, rule number 1, which David Seymour and his Ministry of Regulation trumpets, is consult with the people affected. Who was consulted? Why are you so rushed that you didn't consult the people affected by this? We know that that minister is allergic to unions, but why did you not talk to the CTU? Why did you not talk to the groups of workers who are currently negotiating these agreements? How is this good process? How can we pretend that legislation under urgency with that shabby process has any quality whatsoever?
The budget books.
The Honourable Dr. Deborah Russell. I do have some questions also to ask around process. It's a little hard to pin it to a particular clause in the bill, but it is important that we discuss this, given that we didn't have a select committee process. Now, in terms of the papers that were available to us when the bill was tabled, as the Minister was beginning her speech introducing the bill this afternoon, literally we couldn't get our hands on the bill until after the Minister had started talking. But so amongst them we were able to come across the or maybe I got it from a colleague, the Minister MB's paper, Reviewing Policy Settings, March 2025, which is the pretty vague title, isn't it? But it is all about this bill. And in particular, it's the CAB paper or the MB paper on the bill. And in particular, I think we need to talk about the financial recommendations. We need to understand the costs and benefits of this bill that the Minister is bringing to us today. And it turns out that the particular report is just full of great, big, grey, redacted paragraphs. So I want to know what advice, now obviously the Minister's not going to tell us exactly what the advice was because it's all redacted, but I want to know what sources of advice the Minister asked for and consulted in terms of looking at the financial implications of this bill. And we already know that the Prime Minister has said it's going to save billions of dollars for the government, so that's an interesting little bit of analysis we got from the Prime Minister. It's a shame that we haven't had any more elaboration on that yet. But in terms of the financial recommendations and the financial analysis, I want to know what financial analysis was done for the impact on workers. How much do we think that workers' wages are going to be affected by this bill? We need to know whether perhaps some anticipated pay rises will now be foregone because of this bill. So in particular, I'm thinking of teachers, teacher aides, I think anyone who worked in that space where there is a claim that is now being set aside, just abandoned. What's the impact on their future income? So that's the first part of that question, and it's the direct financial implications for the workers who are affected by this bill. How much are they going to lose out of their back pockets? Now, of course, we're talking about future pay rises that will no longer occur now, but they had a reasonable prospect of getting pay rises because of the pay equity legislation and their claims. How much are they losing now because those claims have just been set aside? So that's the first question. But there's some really other interesting information around in terms of wages for women. And I want to know whether the Minister has taken this into account as well. So I have here a briefing paper from the Institute for Women's Policy Research, and it's an economic analysis of what happens when women's wages are increased. And the particular paper is titled The Impact of Equal Pay on Poverty and the Economy. And very roughly, what it shows is that increasing women's wages for every, I think it was an 8% increase in, 4% increase in women's wages, let me see if I can get the numbers exactly right, providing equal pay to women cuts family poverty in half. Now this is US numbers, it might be different in New Zealand, falling from 8% to 3.8%. So over half, all right, in terms of family poverty. There was a cut of over half in family poverty when women get equal pay. So I want to know, in terms of the financial analysis that has been so blocked out in this report, not just the impact on the workers, but the impact on poverty in New Zealand. We know that pay equity tends to go to reward the lowest paid workers. We know that is money that would have flowed through to families. What is the impact in there? Did the Minister get advice on that as to how the workers and their dependents and broader issues like family policy are affected by the changes that she is bringing into effect?
Madam Chair.
I call the Honourable Brooke van Veldon.
Thank you, Madam Chair. I wish to take the time to answer a few of the questions received so far. In response to Lawrence Sunan, who asked about legal advice that I'd received through this process, any legal advice I receive is legally privileged, as is normal. To Dr. Tracy McLellan, asking about what analysis has been done on the costs or savings associated with the current claims and the changes to this law. This is budget-sensitive information, which I cannot disclose. What I can say, though, is that pay equity claims have been concentrated in the public sector and cost to the Crown have become significant. My policy changes will have a significant reduction in the costs to the Crown. There has been a question from, I believe, forgive me, one of our members, Dr. Duncan Webb, about the Attorney General's advice. I understand that the advice has actually been published on the Ministry of Justice website, as is normal. I understand it has been up for a little while this evening. Why has there been no treaty analysis? Also asked Dr. Duncan Webb. Look, my understanding is that an improved pay equity system will still be available under this law, and I consider that it is consistent. Also from Dr. Duncan Webb, there have been concerns about the retrospective impact of the bill. Look, I consider that it's important that all of the claims are on the same playing field, rather than allowing for two systems to operate at the same time. There is only really one element of the Amendment Act that is retrospective. That is that the review clauses in existing settlements and employment agreements will become unenforceable. This is because the short 3-year time frame in the review cycle does make it quite difficult to determine whether any differences in pay are due to pay equity issues having re-emerged over a short time frame, or if they are to short-term changes in the labour market. I've also got another question here from Dr. Duncan Webb on why we didn't consult Justice on changes in the penalties. The penalties in the Act are civil penalties, not criminal, and the new penalties are consistent with the existing penalties.
Gee, she seems to sit there and go, it's a too short amount of period of time to sit there and do it. We can't tell if it's the market changes or if it's as a result of the Act. She's given that answer for the second time tonight, so I didn't expect twice to have that answer that I didn't know was on my bingo card to get answered twice. The same answer.
I mean, you're winning bingo over here, but I agree with Duncan Webb. Where the fuck is the Attorney General's report? Is Judith Collins that busy dreaming of helicopters that she can't write a report on this? Like, where the fuck is it? I'm trying to find it on the internet. I can't find it.
You still can't find it, and it's, what do you call it, been 5 days?
Where is it?
It's still not up there. That's hilarious.
Yeah, that actually I find is quite concerning. Maybe we need to flick off an email to Dr. Duncan Webb.
Like, I don't know. I mean, where would you go to even find it? I just typed in Google Attorney General Analysis Pay Equity Amendment Bill. Nothing's coming up.
Oh, God.
I'll make some inquiries tomorrow.
Yeah, it's like, I mean, there's departmental disclosure statements that was published on the 1st of May.
That could be a very good question in the House.
But yeah, it's like, but that's not it. No,
Yeah.
Judith Collins' signature isn't on there or anything. No, I can't find it.
I mean, I doubt they would necessarily see Judith Collins' signature on there. We might just get a name, but yeah. Okay.
Thanks for watching. Make sure you're subscribed to our Facebook.